Okay guys, today let's look a little bit at how evidence works. And I'm going to talk about hearsay and double hearsay, particularly as it relates to Ashley Smithline. Obviously she's been in the thoughts of people who are watching these cases because of the situation involving her attorney trying to withdraw out of the case. In light of that coming out, the fact that she did not go forward with her deposition on the 17th and apparently isn't going forward with the deposition that was rescheduled either. And before we get into the evidence piece, really going to talk about the Ashley Smithline DMs. Finish talking about the attorney attempting to withdraw. Remember, he cannot leave the case until the court gives him leave to do that. And he has filed his withdrawal motion in the action where he represents Ashley Smithline. But she was subpoenaed in the Bianco case as a witness. So he's moved to quash or modify the subpoena in that case while his withdrawal motion in the other case is pending. So that's not a good situation for Smithline's case. But on the other hand, if she and her attorney have differences that they cannot reconcile, it's a bridge that you just need to cross. Typically how that resolves is you end up with another lawyer appearing in the case, and maybe that'll happen. It was mentioned by her attorney that she was seeking substitute counsel or needed time to get new counsel, so that could occur. Sometimes counsel leaves. The court gives them permission to leave if the plaintiff agrees, and now the plaintiff is unrepresented. That's not a good place to be. Everybody thinks they can manage and navigate the court system completely. Sometimes they don't even know what they're missing. That's just the truth of it. There are a lot of technical rules and things. So that's not where she wants to be. Could end up with the case folding. Who knows? I don't put odds on anything in particular in this case because it's just hard to predict what's going to happen. And part of that, a lack of predictability to me, is because of Smithline's behavior, that you don't really know what all it is, but from what you can glimpse of it, it doesn't seem obviously in line with somebody who's attempting to prosecute their case in an orderly manner. I mean, Manson's doing that. He's controlling what his communications are. It appears Bianco's doing that. So, and Wood and Gore are pretty much doing that. So then why can't Smithline do it? And that really relates only to her, I think, and what her mental state is. All there is on the record about that is that she was scheduled for deposition and then apparently was going to seek psychiatric care and maybe be excused from the deposition depending on what the results of that were. But reading between the lines, I don't know that that happened or happened in a way that was possible for her attorney to communicate it to the other attorneys. I'm betting it didn't happen. Regardless, the point is that got revealed in these filings that's the reason why the deposition was delayed. And that suggests that at least she perceives herself to be in an extremely fragile state, and probably is so, because there is a DM problem that Ashley Smithline has. She should have gotten off of social media. She definitely shouldn't be posting something that she wasn't running by her attorney, and she definitely shouldn't be DMing people regardless. And I believe that she has been doing that. Now, we'll get into the evidence a little bit where she claims that some of it's hacked, some of it's not hacked. That goes down a pretty serious rabbit hole. But in theory, what Manson's attorney said to the court in his case against Wood and Gore is, hey, when I take Smithline's deposition, we're going to see whether she wrote the DMs that we say she wrote. She'll be able to clear all that up, and it won't be double hearsay anymore. It'll just be hearsay, which is allowed for purposes of the anti-SLAPP motion. So this deposition will cure a lot, and it really would, right? So she could have cured it at this deposition, and she was going to be able to appear remotely, so she'd be on camera like this, not even in the room with the other people. She could have just told whatever the truth was. She also could have put out a statement earlier than that saying, hey, I didn't write these DMs, or I did write these DMs and the context is wrong, or whatever. All of that could have been handled before, certainly could have been handled in the deposition, but it has not happened. The disclaimer that she's made about these DMs is allegedly through other DMs. Again, we'll go down that rabbit hole in just a minute. Over the course of the last two videos I did reporting on the statute about the revival of the statute of limitations, and also this motion to withdraw, I've been accused of being way too sympathetic to the plaintiffs or accusers in this case, Smithline, also way too sympathetic to Manson for taking advantage of this person who's in this state. So maybe I am hitting the middle here, but just going to clear that up from how I think it ought to work. I am sympathetic to Smithline if she is having this mental issue. That's a serious point of weakness, and she's obviously under a lot of stress. I'm sympathetic to that. However, the law can't work on sympathy. It can accommodate it to some degree, but it can't operate off of it. And she had two choices, or three really, if she was abused or felt she was abused. And one was do nothing. Absolutely not saying she should have done that, but she could have done that. The other was to make a complaint to the police and let them handle it. And maybe she did do that. I don't know. At least some of them did. And another choice was to file the civil action to get money from Manson. And that was going to be public when she did it. And that's the route that she took. And if you're going to engage the legal process against somebody, I'm sorry, you have to be able to prosecute that. If you can't do it, you need to get out of the legal system. You need to drop your case. You need to go and do something else, some other way of handling the healing that you need to heal, because you can't let people bring cases against people and put all of this out there and then say, well, of course, I'm not going to testify to any of this, right? I'm just filing this lawsuit and asking for money, but I will not be put under oath to be testifying about it. I'm not sympathetic to that at all. That is not excusable if you're going to prosecute a case against somebody to then refuse to testify against them and think your case is going to move forward. So her case is in a very, very bad way. She's either going to need to use this time that she may get to seek another attorney to get herself in a healthy enough position to do the testifying that she needs to be able to do, or really her case should be dropped by her or thrown out by the court eventually. That's my opinion on this. So that's the limit of my sympathy on it. So let's get out of the intro and get into what this video is really about, which is how the evidence will work. And the connection to what I've been talking about before is obviously the DMs that were submitted by Manson's team in his case against Wood Gore, in which Smithline allegedly said that she was pressured into this situation, that she was told to lie, that she really doesn't want to be involved in it. That was put forward in a declaration by a non-party witness in favor of Manson. And there are many people, I think, who say, well, she's not coming to this deposition because she doesn't want to answer up to that because she obviously did write that stuff. That's completely a fair interpretation of what the situation is. I don't know if it's accurate. None of us can know why she's not coming to the deposition yet, at least. But I think it's pretty fair when somebody won't show up to testimony to say, well, that's because they don't want to back up the other things that they've said. That can definitely be it, right? I mean, that's the highest odds thing that there is. There can be other reasons, including that she's just so mentally broken down that she can't gather herself up enough to appear for a deposition. That can be the case too, and it also might be the case, given how scattered her DMs have been, allegedly, from all over the internet. That might be the case. It's higher odds than I would say in pretty much any other case that I've seen, that she just may not be in a state right now where she can be competent to do this. Again, that has serious ramifications for her own case, and potentially her believability for all of it to begin with. And really, if you're on Manson's team, Smithline having filed this lawsuit could in the end be a gift, because his theory in the Wood Gore case is that these people were recruited and peer pressured into making similar allegations against him for bad purposes. And in that case, could you dream up something better than Smithline filing her lawsuit and then allegedly sending out all these contradicting DMs, some of them saying she was in fact pressured, but in any event, all inconsistent, folding under pressure, and her suit is collapsing? That is consistent with Manson's theory that mentally vulnerable people were used to develop this theory against him. It's not proof of it, but again, is this even bad for Manson at this point? Like, how could this possibly be bad? And I think you can see in the email chain, his attorneys begin to press that point. So let's get into the double hearsay action that many people think is at the root of this, and certainly is important to this. So let's start out with, again, what is hearsay? Well, it's just, in terms of the context we'll talk about it, an evidence rule of a definition of something that generally is not going to be allowed in court unless an exception applies. So in California, it's defined as hearsay evidence is evidence of a statement that was made other than by a witness while testifying at the hearing, and that is offered to prove the truth of the matter stated. except as provided by law, hearsay evidence is inadmissible. Now, that is the general understanding of hearsay across the nation, but remember, every jurisdiction can tweak that or have different exceptions, or sometimes they define things out of hearsay that you would think would be hearsay. But that's the general idea of hearsay. If you're not making a statement in court as the witness, then it's hearsay. But one of the biggest exceptions to hearsay, I shouldn't say that, one of the biggest loopholes in hearsay is the second part of the definition where it says offer to prove the truth of the matter stated. So you can offer hearsay evidence, but if you're not offering it for the truth of the thing, but maybe to provide the context to something or to show something else is true that's incidental to what the statement was, then that hearsay statement can come in. But often, as the attorney, the truth of the thing is exactly what you want the jury to focus on. You just got to get this hearsay statement in there, so you have to find a way where you're introducing it, not for the truth, Your Honor, of what is being said here, but for this other purpose. So sometimes you get the bizarre objections in court that you'll hear, Your Honor, objection, hearsay, and then the other attorney will say, Your Honor, I'm not offering this for the truth of the matter asserted. Isn't that a bizarre thing to hear in court? I'm putting up evidence, Your Honor, but not for the truth of it. It's a weird way to view the world, but that's how it is in the law. So a lot of little tricks get played in court to try and get things in that otherwise would be hearsay without having to get into exceptions, just by being outside of the definition of hearsay. But obviously, everybody wants the statements to come in for the truth of the matter asserted. So if you can't dodge that, then you have to find an exception to it, or else you can't put the evidence in. So hearsay is anything outside of the hearing, right? So when this DM exchange came up by Manson's attorneys in the Wood Gore case, there was nobody at a hearing testifying about it. It was just a declaration by a non-party person. So that's hearsay, right? And then they're telling you what somebody else said, Ashley Smithline allegedly. That's double hearsay. Now, you can get double hearsay into court if it's hearsay by meeting exceptions for both those things. So you'd have to say, Your Honor, there's an exception for what Smithline said, and Your Honor, there's an exception for the declarant. And so therefore, yes, it's double hearsay, but each piece of it can be allowed under its own exception, so it can come in. You could do all that. But generally speaking, double hearsay, come on, bro. I mean, really? So the idea behind the hearsay rule is that to have confidence in the evidence of the testimony of people, they should be making it in court where their demeanor and credibility can be judged by the fact finder and subject to cross-examination. And if you're allowing hearsay, you can't do that. If you're allowing double hearsay, you're really playing telephone tag at some point, right? So the declarations in the Manson case involved double hearsay. So then the Wood Gore team came back and said, hey, look, this is double hearsay. In fact, we've got a DM exchange where she says that she never said any of this stuff. And we're not offering that for evidence because it's too ridiculous to offer double hearsay for evidence. Manson's team almost concedes this point by saying, yeah, okay, it's double hearsay and all that, but we're going to take the deposition of Ashley Smithline. So all we're doing here, Judge, is showing you a forecast of the topic that we're going to get into, which is super material to these anti-SLAPP suits. So in this case, I definitely agree with Holly that if there is no deposition, that the court should not consider this DM exchange because of the fact that it's double hearsay. I'll tell you why in just a minute. I think the defendants are completely right in that. And I don't think Manson's team is going to be able to get around that. Of course, the judge could just love looking at that and want to see it and do it anyway, but I think the law is against that. So that makes it important, the fact that Smithline has refused to do the deposition. Although, of course, in the deposition, she could just say, I didn't write that. How are they going to prove that she did? It's double hearsay. They can't get it in as evidence, and she's going to say, no, I didn't write that. So she could have said that if she'd done the deposition, but it didn't happen. Now, the DM exchange that was submitted in the declaration by the non-party witness, it's definitely a pro-Manson situation by a long shot. But I want to call out Manson's attorney team here for two positive things. One is that they did tell the court, but listen, we're not resting on this. We want to take her deposition. Now, in her deposition, she's going to be able to tell the truth of whether she wrote this stuff, wrote part of it, wrote other things that would have changed the context, or didn't write any of it. She'd be given sworn testimony at that point. So they were seeking her deposition. They didn't not attempt to take her deposition and then just rely on these DMs. And in that deposition, if these things weren't true, she could have said that. So that's credit to them for that. The second thing I give them credit for is we didn't know that the deposition didn't occur. We didn't know that it was rescheduled, and we didn't know that the reason for that was the alleged necessity of psychiatric care. Manson's attorney team didn't leak any of that out. The last we heard from court filings were they were all working together in a collaborative manner to execute discovery for both sides in a reasonable manner. So I also give credit there that they didn't leak any of that out. I know the litigation gets nasty and stuff like that, but think about that. If they were really out to do harm to this woman every chance they got, they didn't leak this, and it is pretty bad. But let's get into the DMs now. So we know the good part for Manson. Coerced into it, pressured into it, really didn't want to be involved in it, told to lie. Big things, right? That's awesome stuff for Manson. It absolutely is. But these DMs are also bizarre. And this will start to get into why should you have a reluctance to rely on hearsay, and particularly double hearsay. So one of the things Smithline allegedly said in this DM exchanges, they told me to lie and speak with no accent. It was truncated. And then the person corresponding with the Ashley Smithline says, why did they make you speak in an American accent out of curiosity? Wait, what? Smithline, wasn't she born in LA? I mean, what other accent is she supposed to have? Pay attention to that here in a moment. But first, I'm going to show the clip from the interview she's talking about. I think the one she's talking about when she was with her attorney, right? Because that's I think the one that's referenced in these DMs. Listen to her voice. So let's do that.
Hi, sorry. Thank you for having us. I was kind of bombarded by Facebook messages, by emails, by Skype calls that I don't know if he remembered he did all of these different things, but we first connected.
Okay. Whatever. There's no particular accent there, I guess. Let's listen to her interview with People magazine, because to me, she hasn't changed her voice or her accent between those two interviews yet. She was told in the second interview to lie and speak with a different accent. So listen to that.
You've found such a strength in numbers, and our stories are all identical. It's disgusting. Like, at least if you're going to be an abusive psychopath, be original. And he wasn't in any way.
Do you hear any big difference there? I mean, I didn't. It sounded to me at least reasonably consistent between those two. But yet in this DM exchange, she's being told allegedly that she had to speak with an American accent. She is American, I think. Then it says, well, why would they do that? She says, be like Evan. Really? I mean, does everybody have to have an American accent? Does that make any sense? What motivation would an interviewer have to say, do not speak with an accent from some other country because it's going to help your case? Esme Bianco speaks with an accent. I don't think that affects her credibility one way or the other. She wasn't told to lie about her accent. That's pretty bizarre there, right? So I think you have an American saying that they're being told to speak with an American accent, implying there is some other accent that they normally speak with. Let's see if there's some more evidence of that. So later on in the exchange, you'll see the person speaking to the alleged Smithline says, are you sure you're not Australian? And then the person answers in a bizarre way, Evan's documentary narrative just needs a certain spin for her billions. Well, there's not billions at stake in any of this, right? There's no $1 billion documentary going on one way or the other. But what an answer is that? Are you sure you're not Australian? So the person involved in this exchange thinks maybe this person is Australian. And remember, in the declaration, which not everything got submitted, just these excerpts of the conversation, there were also videos and pictures and voice recordings and things like that between these people. So doesn't that speak to the fact that whenever that was occurring, the female speaking to the person who was going to file this declaration was speaking with an accent, not an American accent. What kind of accent? Maybe Australian, because the person who submitted the affidavit said, are you sure you're not Australian? Now, this is getting a little bit down the rabbit hole, right? And the person says, no, they just need a certain narrative. So earlier, the Smithline person seems to indicate, yeah, well, I wouldn't speak with an American accent. Normally, they told me to lie about it. I haven't seen evidence of her speaking in some other accent. I couldn't find it. Maybe it's out there, but I didn't see it. And then answering the question, are you sure you're not Australian, without responding back, of course I'm not Australian. What? Why would you think I'm Australian? So there are also other syntax things going on, like saying me self and things like that an American would normally say. Doesn't that make you suspicious? Like, who is really writing this stuff? Is it Smithline? How's that consistent with her personal history, with these comments about the accent and things like this? I mean, what the hell is this? Why is this part of this exchange, right? And what parts of the exchange were you not given? You weren't given any of the voice recordings. You weren't given all of, apparently, maybe the DMs, the videos, the pictures, and things like that. You were given only alleged selected extracts that were the most helpful that this person could come up with for Manson's team. Again, I'm not saying it's not good for Manson, because in fact it's great for Manson. And again, his attorneys weren't saying, I'm going to set on this. They were going to take the deposition to try to prove it. So that's not, questioning what the hell this is not an anti-Manson statement at all. It's an anti-double hearsay statement, because you can't make any sense out of why this person is saying the things they're saying, and you can't know the other person's motive in doing any of this either. They're not subject to cross-examination. You don't know why they selected what they selected, why they asked, are you Australian? Why did you not speak with an accent? You don't know any of these things, but they're really bizarre. She's also making these statements that are prejudicial, highly prejudicial potentially to her case, to an account called Manson is Innocent. And she has sued Marilyn Manson, and she is corresponding with an account, not hiding the ball at all, right? Marilyn Manson, or Manson is Innocent, I think is actually what it was, with an underscore or something at the end of it. But whatever, again, not exactly hiding the ball there on what that person's viewpoint is. And she's telling this person, oh yeah, I wish I wasn't in it. I was pressured to be in it. Isn't that a little weird? Not that it's not true, because weirdness is all over this case in every possible direction. But I still say, regardless of which side you're on, you have to keep your spidey senses tingling when they should be, because just because something supports your case doesn't mean you just swallow that in whole, right? I mean, you should apply a thought process to it. And these DMs are bad for her, good for Manson. Again, Manson's team is going to handle this right. They were going to depose her and get the evidence in the right way, because this stuff is very flaky. So she's confessing to this Manson is Innocent person, oh yeah, my case is, I don't even want to be involved in it. I was pressured to be involved in it. And also, are you sure you're not Australian? And why did you have to talk with an American accent? Does she normally talk with an Australian accent? I don't think so. Again, keep that in mind. But Sean Hodley comes up with a declaration and says, but look at this other DM exchange, Judge, where she's telling a statements against Manson account, which that would make sense that she would correspond more with that one than the other one, since she, again, has sued Manson and claimed that he's guilty of abuse. Did you write any of that? May I ask you, did you write any of that? No. All caps, both letters, with an exclamation mark, and a heart under it from the other person. And then she moved back to the UK. So, no. Here's another double hearsay exchange disclaiming the other double hearsay exchange. Neither one of them are valuable as substantive evidence. And Holly does not try to say that it is, right? She says this is just an example, Judge, that you can find a DM out there to say about anything you want. And it is, her DMs appear to be like a magic 8-ball, where if you just shake up the internet and look at it, you get an answer, and eventually if you keep shaking it, you'll get one you like. Because under her name, hacked or otherwise, there's all kinds of contradictory statements. But if you like double hearsay and you're still convinced that, well, as long as it says what I want it to say, then I'm definitely going to believe this double hearsay item, and it's absolutely accurate, then you're in colliding universes, because Manson has a pro double hearsay statement, and then the Wood Gore team has the opposite statement from Smithline in a double hearsay. You can choose to just believe one of those if you want to, right? Well, nope, she said that it wasn't true in this other double hearsay statement, so that absolutely can't be true. That's all nonsense. That's not any more valuable than the original double hearsay statement. But if you love and heart the original double hearsay statement, how can you then hate and disclaim the second double hearsay statement where she said she didn't do it? I live in this universe where double hearsay is just basically garbage. You can't trust any of it. You can look at it for narrative and you can see how it's going to potentially impact the case, but you can't really lean on it or believe it too much, right? It needs to get tested in a more credible format. And again, that is exactly what Manson's attorneys tried to do. And it's their good evidence, right? They're not stopping on that. They're saying, we want to pursue this and try and prove it. And they haven't been able to do that with Smithline. Again, I think it's a reasonable assumption, if one chooses to make it, that the reason she won't show up for this deposition is she doesn't want to answer for things that she said in DMs. We don't even know what all she said in DMs. These are just the two things that have been put forward in court. And let's chase it down, because if you love double hearsay, you're just going to fall over in joy at the prospect of triple hearsay. Triple hearsay kind of entered the cultural lexicon in the case of Oreo versus Speedwagon, where the declarant, the plaintiff, said, I heard it from a friend, who heard it from a friend, who heard it from another, you've been messing around. Now that is some serious triple hearsay, and to the credit of that person, they said, I don't believe it, not even for a minute. And they spent the rest of the song trying to find corroborating evidence one way or the other. So good. Don't believe triple hearsay stuff. But let's look at a little triple hearsay. So you've got Smithline, okay, saying something allegedly outside of court. That's a layer of hearsay. We may even go quadruple here. Let's see how this stacks up. Then you've got this Phoenix person making an affidavit saying this is the exchange I had with Smithline. So now you're at the double hearsay. But then there are also DMs on the internet allegedly from this Phoenix person to someone else talking about the process of this conversation with Smithline, and then allegedly saying, I don't think I was actually ever talking to Smithline. And you maybe still got the double-ish, triple-ish hearsay situation, but those DMs are revealed by another person, right? Someone else that has been shown to me, and I think other people have seen it on the internet too, saying, hey, I had these DMs with the person who submitted the affidavit about Smithline, and that person said that this person probably wasn't Smithline, that they didn't believe that it was Smithline, and that raises some interesting questions. First of all, is any of these new DMs actually true? Are any of them real? Are they about real people, about the real things that they experienced? If your test for that is, well, let me read it and see what it says, and if I agree with what it says, then I'm going to believe it, and if I don't agree with it, then I won't believe it. That's just not a good test, right? The test is you really can't put much faith into any of this stuff. But I think it is illustrative for the point that if you go down the rabbit holes of just rumor mill situations, layers and layers of hearsay, you can kind of find whatever you want. You're not authenticating any of it. So in this case, this person allegedly said, hey, I don't think I was ever talking to Smithline, and says other things that indicate that this is a person who was a fan of Manson. That's not surprising if it is that person. Manson is innocent. That's probably a fan of Manson, right? And wanted attention from Manson and got upset when that didn't come, maybe because of statements about Manson's wife or whatever, that not enough attention was paid back for the contribution of providing Smithline's DMs to Manson's team. Then this person then says, hey, I don't think that was ever Smithline in the first place. Now, if that's a belief this person had before they filed the affidavit, they should not have been filing the affidavit, right? That shouldn't have occurred. If all this other hearsay nonsense is true. It's all if, right? It's all if. And then the speculation is, well, then who were you talking to, right? Who was this other person? And if these DMs aren't real in this particular case, where'd they come from? Now, it's also possible that they were made up by a hacker or whatever, as Smithline says. And an interesting thing is Smithline says that in the Holly materials, and also this deep rabbit hole DMs between other people say that the person who got the DMs from Smithline now says, maybe that probably wasn't who I was talking to. Who was it? Now, these fake, I shouldn't say fake, because to me it's all fake until somebody proves it. These deep dive ultra hearsay things say, well, maybe it was Ilma, because of this Australian accent. Well, I don't buy that. That's way too far down the line for me. I mean, what possible motive could she have to be torpedoing Smithline's case, and then it would come back on her in her own case where Manson is suing her? Doesn't that seem ridiculous? And what are you, an expert on what Ilma Gore sounds like? That doesn't make any sense. The other thing is, bizarrely, because she's a twin, there's another person who probably sounds just like her, which is her sister Brighton, who is on Manson's side, and who, to me, out of the two, if one had motive to come up with some evidence against Manson, it would be her. But I am not accusing her of that. There is zero evidence that she did this. My point is, if you're going off a voice pattern, how do you really know one from the other? Then, as it turns out, I did some research, and there are more than two Australians. There's, in fact, lots of Australians. So if somebody were speaking with an Australian accent, it could be any number of people. It could also be somebody faking an accent. It could also be with someone with a real accent that the person who was listening to this thought was Australian, because I don't know if there's some master person who can tell where every accent comes from. I don't know. One thing, as I said earlier in the video, that did strike me is the DM exchange when the person asked, why did you not speak with an accent, and are you sure you're not Australian? Those seem to be genuine questions to me, and the Smithline answers don't seem to be in line with who she is as a person. Basically saying that she was told not to speak with her normal accent, and then not really saying, what are you talking about? And of course, I'm not Australian. That's weird. So all this is to say is that the approach that Manson's attorneys wanted to take, which is to get some direct evidence from Smithline, that still would be hearsay, okay, because it's a deposition outside of this hearing, but it would be sworn testimony at least. And then they could call her as a witness later, and in theory, her testimony would be consistent with that deposition. And the one layer hearsay could be used to rebut the anti-SLAPP motion. So they were going to take her deposition to put all this to rest one way or the other, and she didn't show up for it. That's really negative for her. Draw whatever inference at this point that you want to draw from that. My only point is, I can't rely on any of these second layer, third layer, fourth layer hearsay documents because none of them are authenticated in any real way. And if you read them closely, like the original one submitted by Manson's team, they're internally inconsistent with what you think the truth would be if these were just truthful statements. A part of that could just be Smithline's mental state is such that she can't make but so many consistent statements in a row anyway. Maybe, but again, this whole thing about what about all this accent stuff and are you sure you're not Australian? That's pretty weird to me, because I had never heard her sound Australian in anything where I've heard her speak. So it indicates to me that the person who was getting the DMs and having the voice calls was talking to somebody who they were pretty confident sounded like an Australian person. It's all weird, right? That's all very weird. So there's a lot of people with a lot of issues in this case, a lot of varying motives, whether it's to get money, whether it's to avoid giving money, whether it's to get attention from Manson or get attention from any of the women who are accusers or the defendants, Wood or Gore. People have different motives, and social media accounts can be hacked. People can also get drunk or high and say things on social media that they can't believe they said later. That's why it's all nonsense, and that's why one of the few times I can say that the law is doing a thing right here, when it has some rules on what kind of evidence can ultimately be considered by a fact finder. There's got to be some level of credibility to the evidence and some ability to test it. So that's what I have to say on these DMs is, are they real or are they not real? You read it yourself and go beyond that I want it to be true or I don't want it to be true, and look at it and say, does this really even make any sense? And maybe Manson's team's right that, and maybe here it's Manson's team and also the Wood Gore team are right that none of this should really be considered. It's got to be more direct testimony from the people involved that this has to be tested better than any of these DM exchanges. Because I think the attorneys are kind of in line with each other on that, and certainly I agree with it. Well, that's it until the next weird, bizarre thing happens in this case. I can't believe there's this much action going on in these cases, because cases take so long. Usually there's lengthy dry spells, and we've got to have one soon. But anyway, that's what I think about this. I'm interested to read the comments as always. I'm sure I'll be told that you're way too positive for the women and you're way too positive for Manson. And I'm not really trying to be that here. I'm just talking about the rules of evidence and maintain your personal skepticism so you don't get suckered into something that's too good to be true in either direction. Well, that's it. Thanks. Bye.